The Supreme Court chamber fell into stunned silence as Chief Justice John Roberts stared down at the woman standing confidently at the petitioner's table. Stoya, the former adult film actress turned acclaimed feminist writer and legal advocate, stood perfectly composed in a sharp black suit, her platinum blonde hair pulled back in a professional bun. What had started as what many expected would be a routine oral argument about sexual assault legislation had just taken an extraordinary and unprecedented turn. "Miss Stoya," Chief Justice Roberts began, his voice carrying unmistakable skepticism, "this court has reviewed your amicus brief extensively, and frankly, I find it difficult to believe that someone with your background possesses the legal expertise necessary to address such complex constitutional questions about sexual assault law and victim protection." The statement sent shockwaves through the packed courtroom. Legal scholars shifted uncomfortably in their seats. Veteran Supreme Court reporters raised their eyebrows in disbelief, and the gallery erupted in barely contained whispers. Never before had a Chief Justice so directly questioned an advocate's qualifications based on their past profession, especially in a case involving sexual assault legislation. But Stoya didn't flinch. Instead, she calmly opened a thick leather portfolio that contained years of meticulous legal research, her movements deliberate and confident. What happened next would transform this courtroom confrontation into one of the most memorable Supreme Court arguments in modern history, proving that the most powerful legal minds can emerge from the most unexpected places, and that personal experience can be the foundation for groundbreaking legal advocacy. Before we dive into this extraordinary legal showdown, make sure to like this video and subscribe to our channel for more incredible stories of transformation, courage, and the triumph of justice over prejudice. The tension surrounding this Supreme Court case had been building for 2 years, ever since the controversial ruling in Morrison v. State of California had struck down key provisions of the Violence Against Women Act, leaving sexual assault victims with severely limited legal protections. The case that brought everything to the court's attention was Harrison v. Federal Bureau of Investigation, a complex constitutional challenge involving federal oversight of sexual assault investigations and the rights of victims in the criminal justice system. What most legal observers didn't know was that Stoya had been quietly building one of the most comprehensive legal advocacy organizations in the country. After leaving the adult entertainment industry in 2013, she had enrolled in law school at New York University, completing her Juris Doctor with highest honors while simultaneously earning a master's degree in criminal justice. Her thesis on consent, coercion, and constitutional protection in sexual assault law had won the university's most prestigious award for legal scholarship. Following graduation, Stoya had founded the Sexual Assault Legal Defense Initiative, a nonprofit organization that provided legal representation to assault victims while challenging inadequate legislation through strategic litigation. Over the past 5 years, her organization had won dozens of cases, established important legal precedents, and fundamentally changed how courts approached sexual assault prosecutions. The case before the Supreme Court was the culmination of her legal strategy. Harrison involved a federal agent who had sexually assaulted multiple women while using his official position to intimidate victims and discourage reporting. When the FBI failed to properly investigate the allegations, Stoya's organization had filed a federal lawsuit challenging the adequacy of existing legal protections for assault victims and the government's constitutional obligations to ensure justice. Her 60-page amicus brief in the case had stunned legal experts with its sophistication and innovation. Drawing on constitutional law, criminal procedure, feminist legal theory, and comparative international analysis, Stoya had crafted arguments that offered new frameworks for understanding how sexual assault law intersected with constitutional protections. Major law schools were already incorporating her brief into their curricula as an example of cutting-edge legal thinking. Chief Justice Roberts, at 71 years old, had presided over the court with the confidence that came from a distinguished legal career: Harvard Law Review, Supreme Court clerk, Solicitor General, and nearly 2 decades leading the nation's highest court. Known for his sharp questioning and occasional condescension toward advocates he deemed unprepared, Roberts had developed a reputation for exposing weak arguments through relentless logical challenges. when Stoya had been granted 30 minutes to argue in support of enhanced federal protections for sexual assault victims. An unusual opportunity for someone representing a nonprofit organization. Most observers assumed it was the court's attempt to hear directly from victim advocacy groups. Few had bothered to research Stoya's extensive legal credentials or the groundbreaking work her organization had accomplished. "This isn't a political rally," whispered a veteran attorney to his colleague in the gallery. "Constitutional law requires years of specialized training. She's going to be completely out of her depth against these justices." The stakes were enormous. The case involved fundamental questions about federal authority to protect individual rights, the constitutional obligations of law enforcement agencies, and the balance between state and federal jurisdiction in criminal matters. If Stoya's arguments prevailed, it would establish new precedents for victim protection and government accountability in sexual assault cases. If she failed, not only would current inadequate protections remain in place, but her innovative legal theories would be dismissed as the amateur advocacy of someone seeking attention rather than justice. As Stoya approached the podium, she moved with the quiet confidence of someone who had spent years preparing for this moment. Unlike many first-time Supreme Court advocates who appeared nervous before the justices, she carried herself with the poise of someone who understood both the law and the human cost of legal failure. "Mr. Chief Justice, and may it please the court," Stoya began, her voice clear and authoritative, filling the chamber with unmistakable conviction. "The Constitution's guarantee of equal protection under the law becomes meaningless when government agencies systematically fail to investigate and prosecute sexual assault cases. Today's legal framework has created a system where perpetrators operate with effective impunity, while victims are denied the justice that constitutional principles demand." Her opening was powerful and legally sound, but Chief Justice Roberts, who had been reviewing Stoya's background with obvious skepticism, saw an opportunity to expose what he perceived as activism masquerading as legal expertise. While justices typically allowed advocates to develop their arguments before intense questioning, Roberts broke protocol to challenge Stoya's credibility immediately. "Miss Stoya," Roberts interrupted, his tone carrying unmistakable condescension, "while I understand your personal passion for this issue, I find it difficult to believe that someone with your background possesses the constitutional expertise necessary to address the complex federal-state jurisdictional questions at stake here. Your brief seems to fundamentally misunderstand the delicate balance between federal authority and state sovereignty that this court has carefully maintained for over 2 centuries." A murmur ran through the courtroom at the unusually personal and aggressive nature of the challenge. Justice Sonia Sotomayor shifted visibly in her seat, while Justice Elena Kagan frowned at the inappropriate focus on Stoya's personal history rather than her legal arguments. The gallery watched intently as Stoya paused, meeting the Chief Justice's hostile gaze directly. Those familiar with Stoya's media appearances and written work recognized the composed determination that always preceded her most powerful advocacy. "Chief Justice Roberts," she replied with unwavering confidence, "I believe my argument is entirely consistent with this court's precedent in United States v. Morrison, Tennessee v. Lane, and City of Burney v. Flores. But perhaps we should examine the constitutional text and enforcement mechanisms together, along with the empirical evidence of systematic government failure to protect constitutional rights." She opened her portfolio and retrieved several carefully organized documents, including original constitutional sources, statistical analyses, and legal precedents that she had clearly researched exhaustively. This wasn't the emotional advocacy Roberts had anticipated. This was sophisticated constitutional analysis, backed by comprehensive legal research. What followed was the opening move in a legal confrontation that would leave the court, the legal community, and advocates nationwide stunned by its brilliance and power. Chief Justice Roberts, realizing his initial attack hadn't rattled Stoya, leaned forward with increased hostility. "Ms. Stoya, your brief argues that the federal government has constitutional obligations to ensure adequate sexual assault prosecutions, but you've overlooked fundamental principles of federalism established in cases like United States v. Lopez. Criminal law has traditionally been a state responsibility. How do you reconcile your position with constitutional limitations on federal power?" The question was designed as a sophisticated legal trap, one that required deep understanding of constitutional federalism and the delicate balance between state and federal authority. Lopez was indeed a foundational case limiting federal power, but its application to victim protection was complex and nuanced. Without hesitation, Stoya responded with precision that surprised everyone in the chamber. With respect, Chief Justice Roberts, I have not overlooked Lopez or its progeny, she began, turning to specific pages in her brief with practiced confidence. In fact, on pages 18 through 23, I addressed Justice Rehnquist's majority opinion in detail, along with the subsequent clarifications in United States v. Morrison and the more recent developments in NFIB v. Sebelius. Her voice gained strength as she continued. While Lopez established important limitations on federal commerce power, it specifically preserved federal authority to protect individual constitutional rights under the 14th Amendment's enforcement provisions. Justice Kennedy's concurrence in Lopez explicitly noted that federal intervention remains appropriate when states systematically fail to protect constitutional guarantees. The courtroom fell silent as Stoya demonstrated not just familiarity with Lopez, but comprehensive understanding of how it fit within the broader framework of constitutional federalism. She wasn't simply citing cases. She was demonstrating mastery of complex doctrinal relationships that many practicing attorneys struggled to understand. Moreover, Stoya continued with growing authority. I've documented systematic failures by state authorities to investigate and prosecute sexual assault cases, creating precisely the kind of constitutional crisis that justifies federal intervention under Section 5 of the 14th Amendment. My brief includes statistical analysis from all 50 states showing conviction rates, investigation patterns, and victim protection measures that demonstrate widespread denial of equal protection. Justice Samuel Alito, known for his aggressive questioning style, jumped in with obvious skepticism. Ms. Stoya, those are interesting statistics, but how do you account for our precedent in Flores v. City of Burney? This court held that federal remedial measures must be proportional and congruent to constitutional violations. Your proposed federal oversight seems to exceed those constitutional boundaries. Justice Alito, I believe Flores actually supports rather than undermines my position, Stoya replied, drawing surprised looks from court observers. Directly challenging a justice's interpretation of precedent was a bold move that required absolute confidence in one's legal analysis. While Flores established proportionality requirements for federal remedies, Chief Justice Rehnquist's majority opinion specifically noted that extensive federal intervention becomes appropriate when state failures are both systematic and widespread. She turned pages in her meticulously organized notes. More importantly, Flores dealt with religious freedom protections, where federal interests were less compelling than in cases involving violent crime and physical safety. In Tennessee v. Lane, decided 5 years after Flores, this court explicitly held that federal intervention to protect access to justice satisfies proportionality requirements when state systems systematically deny constitutional rights. The dynamic in the courtroom was shifting dramatically. Justices who had initially appeared skeptical were now fully engaged, several taking detailed notes as Stoya demonstrated sophisticated understanding of constitutional doctrine. Court observers noted that Justice Clarence Thomas, who rarely spoke during oral arguments, was paying unusually close attention to her responses. Justice Brett Kavanaugh entered the discussion with what appeared to be genuine curiosity rather than hostility. Ms. Stoya, your constitutional framework is compelling, but there's a practical concern about implementation. If we accept your analysis, how do we prevent federal oversight from becoming an unworkable bureaucratic burden on state criminal justice systems? Thank you for that crucial question, Justice Kavanaugh. Stoya responded with obvious preparation for this line of inquiry. I'm not proposing federal micromanagement of state criminal justice systems. Instead, I'm suggesting that the Constitution requires federal intervention only when state systems demonstrate systematic patterns of failure to protect victim rights. She referenced specific sections of her brief with practiced ease. The framework I've outlined establishes clear metrics for measuring state compliance with constitutional obligations, investigation response times, prosecution rates for reported assaults, victim protection measures, and training standards for law enforcement. Federal oversight would only trigger when states fall below constitutional minimums in these measurable areas. Chief Justice Roberts, clearly surprised by Stoya's command of both constitutional theory and practical implementation, attempted a different approach. Ms. Stoya, your brief cites extensive social science research about sexual assault reporting and prosecution patterns. How can we be confident that this empirical evidence supports the constitutional conclusions you're drawing? It was exactly the kind of question designed to expose advocates who relied on statistics without understanding their legal implications. Roberts suspected Stoya might have included social science data without comprehending how it related to constitutional analysis. Stoya smiled slightly, recognizing the challenge she had spent months preparing to address. I'm grateful you raised that question, Chief Justice Roberts. The empirical evidence is essential to constitutional analysis because it demonstrates the scope and systematic nature of the equal protection violations at stake. From memory, she outlined a methodology and findings of her comprehensive research. Over the past 3 years, my organization analyzed sexual assault reporting, investigation, and prosecution data from all 50 states, controlling for population, crime rates, and resource allocation. The results show statistically significant disparities that cannot be explained by legitimate law enforcement priorities. She continued with remarkable precision. For example, reported sexual assaults result in prosecution 23% less frequently than other violent crimes of comparable severity, even when controlling for evidence quality and witness cooperation. This disparity exists across all demographic categories, but is significantly worse for women of color, LGBTQ victims, and women with unconventional backgrounds. Justice Elena Kagan, visibly impressed by the comprehensive nature of Stoya's research, interjected, Ms. Stoya, this empirical analysis is extraordinary. Did you conduct this research personally, or did you collaborate with academic institutions? For the first time, Stoya showed a hint of personal pride in her accomplishments. Justice Kagan, while I certainly consulted with leading researchers and statisticians, the data collection, analysis, and constitutional interpretation were developed by my organization's legal team, which I personally direct. We've been building this evidence base for 5 years, specifically to support constitutional challenges like the one before this court today. A buzz ran through the courtroom as observers realized the depth and sophistication of Stoya's legal work. This wasn't celebrity activism. This was serious legal scholarship backed by comprehensive empirical research. Chief Justice Roberts, whose earlier dismissiveness now seemed increasingly inappropriate, shifted uncomfortably as he recognized the strength of Stoya's presentation. Justice Sotomayor, sensing an opportunity to move beyond the personal attacks and focus on legal substance, posed a question that would allow Stoya to demonstrate the practical applications of her constitutional theory. Ms. Stoya, returning to the specific case before us, how would your proposed constitutional framework apply to the Harrison situation? Walk us through how federal oversight would have prevented the systematic failures that occurred in this case. Stoya turned directly to address Justice Sotomayor with obvious relief at the opportunity to discuss practical applications of her legal framework. Justice Sotomayor, the Harrison case illustrates exactly why current legal protections are constitutionally inadequate and why federal oversight is essential. She methodically outlined her analysis. Agent Harrison used his federal position to sexually assault multiple women over an 18-month period. When victims reported these crimes to local authorities, they were told it was a federal matter and referred to the FBI. When they reported to the FBI, they were told it was a personnel issue and referred to internal affairs. This jurisdictional shuffle allowed Harrison to continue victimizing women while avoiding any meaningful investigation. Her voice gained power as she continued. Under my proposed framework, federal oversight would have required clear protocols for investigating crimes committed by federal agents, mandatory victim protection measures, and regular auditing of compliance with constitutional standards. More importantly, Victims would have had federal court access to challenge inadequate investigations, ensuring that bureaucratic failures couldn't deny constitutional protections. Justice Amy Coney Barrett, who had been listening intently throughout the argument, spoke with a question that reflected serious engagement with Stoya's constitutional theory. Ms. Stoya, your framework raises interesting questions about the relationship between individual constitutional rights and institutional accountability. How do we balance victims' rights to equal protection with the practical challenges of reforming complex bureaucratic systems? The question reflected not skepticism, but genuine intellectual curiosity, a sign that Stoya's arguments were being taken seriously at the highest level of constitutional analysis. Thank you for that essential question, Justice Barrett, Stoya replied, her confidence now unmistakable. The Constitution doesn't guarantee perfect systems, but it does require that government institutions operate with constitutional minimums of effectiveness and accountability. When systematic failures deny entire categories of citizens equal protection under law, constitutional obligations override administrative convenience. She continued with growing authority. The framers of the 14th Amendment understood that constitutional rights become meaningless without effective enforcement mechanisms. They specifically granted Congress broad power under Section 5 to ensure that constitutional guarantees translate into practical protection. My framework simply applies those enforcement powers to modern challenges that the framers couldn't have anticipated, but that clearly fall within their constitutional vision. Stoya reached into her portfolio and removed historical documents that she had clearly researched extensively. I've traced the legislative history of the 14th Amendment's enforcement provisions, including the congressional debates and the subsequent civil rights cases of the 1870s and 1880s. The evidence demonstrates that the framers intended federal power to be robust enough to overcome systematic state failures to protect individual rights. Justice Thomas, who had remained silent but clearly engaged throughout the argument, finally spoke, a rare occurrence that caused reporters to lean forward with anticipation. Ms. Stoya, your originalist approach to 14th Amendment interpretation is noteworthy. You've shown that systematic failures to protect sexual assault victims violate constitutional principles that the amendment's framers intended to address. But how do we ensure that federal remedies don't exceed constitutional boundaries? The question went to the heart of conservative constitutional theory, the balance between robust enforcement of constitutional rights and limitations on federal power. It was exactly the kind of sophisticated inquiry that separated serious constitutional advocates from mere activists. Stoya responded with precision that demonstrated her deep understanding of constitutional doctrine. Justice Thomas, the key is ensuring that federal remedies are tailored specifically to documented constitutional violations rather than general policy preferences. My framework doesn't federalize criminal law. It establishes constitutional minimum standards for protecting victim rights and provides federal oversight only when states systematically fail to meet those standards. She referenced her carefully organized materials. The Commerce Clause cases like Lopez and Morrison establish important limits on federal power, but they explicitly preserve federal authority to protect individual constitutional rights under the 14th Amendment. The question isn't whether federal power exists, but whether its exercise is proportional to the constitutional violations documented. Stoya continued her analysis with remarkable sophistication. I've designed the oversight framework to include sunset provisions, regular review of state compliance, and mechanisms for returning full authority to states once they demonstrate consistent constitutional compliance. This ensures that federal intervention remains remedial rather than punitive, and temporary rather than permanent. This nuanced response, addressing conservative concerns about federal overreach while maintaining robust protection for constitutional rights, demonstrated Stoya's sophisticated understanding of how constitutional doctrine evolved through careful balancing of competing principles. Chief Justice Roberts, now fully engaged with the substance of Stoya's constitutional arguments rather than her personal background, posed a question that indicated serious consideration of her legal framework. Ms. Stoya, if we were to accept your constitutional analysis, what specific implementation mechanisms would you recommend to ensure that federal oversight enhances rather than replaces state criminal justice systems? It was the kind of question typically reserved for the most respected constitutional advocates, an invitation to help shape practical applications of constitutional doctrine rather than merely argue theoretical principles. Stoya didn't hesitate. Chief Justice Roberts, I've developed a comprehensive implementation framework based on successful federal oversight models in voting rights, civil rights, and environmental protection. She held up a detailed document that contained specific policy recommendations. First, I propose establishing clear, measurable standards for constitutional compliance in sexual assault cases, minimum investigation timeframes, required victim protection measures, training standards for law enforcement, and prosecution rate benchmarks adjusted for case complexity and evidence quality. She continued with practiced precision. Second, federal oversight would operate through collaborative agreements with state authorities rather than hostile federal intervention. States meeting constitutional standards would receive federal funding and technical assistance. States falling below standards would receive additional federal support to improve their systems, with direct federal intervention only as a last resort for persistent constitutional violations. Stoya concluded with quiet authority. This approach protects victim rights while respecting federalism, provides clear guidance to state authorities while maintaining flexibility for local conditions, and ensures constitutional compliance while supporting rather than replacing state criminal justice systems. As Stoya's allotted time began to expire, the transformation in the courtroom was remarkable. What had begun as what many expected would be a perfunctory hearing for a victim advocacy organization had become a serious examination of constitutional principles and practical applications of federal authority to protect individual rights. Instead of the customary abrupt termination of argument time, Chief Justice Roberts allowed Stoya to complete her presentation, a rare courtesy that signaled the court's recognition of the significance of her constitutional arguments. "Thank you, Ms. Stoya," Roberts said, his tone markedly different from his initial hostility. "Your constitutional analysis has been exceptionally thorough and well-researched. The court will carefully consider the framework you've presented." The simple acknowledgement carried profound subtext, a recognition that Roberts' attempt to dismiss Stoya based on her background had backfired completely, instead revealing a legal mind of extraordinary capability and preparation. As Stoya gathered her materials and returned to her seat, the government's attorney approached the podium with obvious trepidation. The dynamic of the case had shifted fundamentally. What had begun as a routine defense of existing legal frameworks had transformed into an uphill battle against a constitutional theory that had clearly resonated with justices across the ideological spectrum. Legal reporters in the courtroom immediately recognized they were witnessing a historic argument, one that might reshape both sexual assault law and constitutional doctrine while challenging assumptions about who could provide meaningful legal advocacy on complex constitutional questions. The aftermath of what legal commentators quickly dubbed the Stoya argument spread through legal and advocacy circles with unprecedented speed. Within hours, law professors were incorporating the oral argument transcript into their constitutional law and criminal justice courses. Legal scholars across the political spectrum weighed in, many expressing surprise and admiration for the sophistication of Stoya's constitutional analysis and empirical research. Jeffrey Toobin, CNN senior legal analyst, delivered perhaps the most concise assessment. "I've been covering the Supreme Court for over 2 decades, and I've rarely seen such a comprehensive constitutional argument supported by such extensive empirical research." Stoya didn't just advocate for sexual assault victims. She presented a masterclass in how constitutional principles should be applied to modern civil rights challenges. The following morning, hashtags like #ConstitutionalAdvocateStoya and #VictimRightsMatter trended across social media platforms. Clips of Stoya citing constitutional framers and explaining complex federalism doctrine from memory circulated widely, garnering millions of views from people who had known her primarily from her adult film career or feminist writing. Legal blogs and academic journals published immediate analyses of Stoya's constitutional framework. The Harvard Law Review announced plans for a special symposium on federal authority and victim protection, Constitutional Frameworks for Modern Civil Rights Enforcement. Yale Law School scheduled a conference featuring leading constitutional scholars discussing the implications of Stoya's legal theories. 3 days after the argument, the New York Times published a comprehensive profile revealing the extent of Stoya's legal education and advocacy work that had previously remained largely unknown. The article detailed her law degree from NYU, her organization's impressive track record of successful litigation, and her role in developing innovative legal strategies for protecting assault victims. She never sought publicity for her legal work, said Professor David Martinez, who had supervised Stoya's law school thesis. She was focused entirely on building legal frameworks that could provide real protection for vulnerable people. Her combination of personal experience, legal training, and empirical research created insights that purely academic approaches couldn't provide. The article revealed that Stoya's sexual assault legal defense initiative had won precedent-setting cases in federal courts across the country, established legal clinics at 5 law schools, and trained hundreds of attorneys in victim advocacy techniques. Her organization's research had been cited in legislative hearings, judicial opinions, and academic publications nationwide. Professional legal organizations responded with remarkable speed. The American Bar Association invited Stoya to lead a task force on constitutional approaches to victim protection. The National Association of Women Lawyers announced plans to establish the Stoya Fellowship for advocates working on gender-based violence cases. Law school applications from women and minorities increased dramatically following the widely publicized argument, with many applicants citing Stoya's example as inspiration for pursuing legal careers focused on civil rights advocacy. Stoya herself maintained her characteristic focus on substance over publicity. In a brief statement released through her organization, she said, "Constitutional law should serve real people facing real challenges. I'm grateful the court engaged seriously with legal arguments that could strengthen protection for sexual assault victims, and I hope their decision advances both constitutional principles and practical justice." 10 weeks after oral argument, the Supreme Court issued its opinion in Harrison v. Federal Bureau of Investigation. In a groundbreaking 6-3 decision, the court ruled that systematic failures by government agencies to investigate and prosecute sexual assault cases violated the Equal Protection Clause, and that federal oversight was constitutionally required when state systems demonstrated persistent inadequacy. Chief Justice Roberts assigned majority opinion to Justice Barrett, a choice that legal observers interpreted as recognition of the case's significance for women's rights and constitutional protection. Barrett's opinion directly incorporated many elements of Stoya's constitutional framework, establishing new precedents for federal authority to protect individual rights when state systems proved inadequate. The opinion quoted Stoya's oral argument extensively and adopted her 3-part test for determining when federal intervention became constitutionally required. A footnote specifically praised petitioners' exceptional empirical research and constitutional analysis that provided the court with essential evidence for understanding the scope and systematic nature of the constitutional violations at stake. Justice Thomas wrote a concurring opinion that praised Stoya's originalist analysis of 14th Amendment enforcement powers. Justice Sotomayor's concurrence emphasized the practical importance of effective constitutional enforcement for protecting vulnerable populations. Perhaps most significantly, Chief Justice Roberts added a personal observation in a separate concurring opinion. This case demonstrates the importance of listening to advocates who bring both legal expertise and lived experience to constitutional questions. The court's understanding of these issues was greatly enhanced by petitioners' comprehensive legal analysis, informed by real-world knowledge of the challenges facing sexual assault victims. The practical impact of the decision was immediate and transformative. Within months, federal agencies developed new protocols for investigating sexual assault cases involving federal personnel. State governments began reforming their criminal justice systems to comply with the court's new constitutional standards. Victim advocacy organizations received federal funding to implement the oversight mechanisms Stoya had proposed. For Stoya personally, the case established her as one of the nation's leading constitutional advocates. Harvard Law School offered her a visiting professorship to teach constitutional law and victim advocacy. The MacArthur Foundation awarded her a Genius Grant, recognizing her innovative combination of legal scholarship and practical advocacy. More importantly, her success had transformed how the legal community understood the relationship between personal experience and legal expertise. Law schools began recruiting more diverse students and faculty, recognizing that different backgrounds could provide valuable insights into how constitutional principles applied to modern challenges. A year after the Supreme Court decision, Stoya published Constitutional Protection in Practice, Federal Authority and Victim Rights, a comprehensive analysis of how constitutional law could be reformed to provide better protection for vulnerable populations. The book became required reading in constitutional law courses nationwide and established new frameworks for understanding federal authority to protect individual rights. The broader impact extended far beyond legal circles. Stoya's transformation from adult film actress to Supreme Court advocate became a powerful symbol of personal reinvention and the potential for individuals to contribute meaningfully to social progress regardless of their backgrounds. In interviews following the book's publication, Stoya reflected on her journey from entertainment to legal advocacy. Constitutional law is ultimately about protecting human dignity and ensuring that government serves all people equally. My previous experiences taught me about vulnerability and exploitation in ways that informed my understanding of how legal systems can either protect or fail the people who need them most. She continued, "The Supreme Court case wasn't about my personal story. It was about building legal frameworks that could protect countless women facing similar challenges. But I hope my experience demonstrates that valuable legal insights can come from unexpected places and that our constitutional system is strongest when it incorporates diverse perspectives on what justice means in practice." The Stoya case became one of the most studied Supreme Court arguments in modern legal education, not just for its constitutional significance, but for what it revealed about the potential for personal experience to enhance rather than compromise rigorous legal analysis. Her legacy extended beyond the specific legal victories to fundamental changes in how the legal profession understood expertise, advocacy, and the relationship between personal background and professional credibility. She had proven that constitutional brilliance could emerge from unconventional paths and that the most powerful legal arguments often came from advocates who understood both legal theory and human reality. Most importantly, she had demonstrated that in America's constitutional system, the power of well-researched legal arguments ultimately transcended social prejudices about who deserved to be heard in the nation's highest courts. Her journey from adult entertainment to constitutional advocacy became an inspiration for anyone who had been told their background disqualified them from meaningful contribution to legal and social progress. Thank you for watching this remarkable story of constitutional advocacy and legal triumph. If you found this account of personal transformation and the power of rigorous legal preparation inspiring, please hit the like button and subscribe to our channel for more stories of justice, perseverance, and the ongoing fight to ensure that constitutional protections serve all Americans. Leave a comment below with your thoughts on how we can better support diverse voices in legal advocacy and ensure that personal experience enhances rather than undermines serious constitutional analysis.